there's any dispute as to that point, but you know, we're a long way from racial predominance to have the plaintiffs come in with a map that in order to remedy the race-based problem that exists, the violation of voting rights based on race, itself takes race into account.
Well,
that's what Milligan said 3 years ago.
The problem, I mean...
And that wasn't a stereotype issue, and it wasn't a kind of like we're based on past conditions issue. We're based on current conditions, which is that we just proved a violation of people's voting rights based on current conditions.
Stereotyping is always the main injury in a Shaw case. It's always the injury when race predominates. And
but you're asking for changes to Section 2, which is not the Shaw case. That's the confusion.
Well,
I understood that the illustrative maps that the plaintiffs bring in the beginning of a Shaw case is part of their showing that we have a problem. They're illustrative. They're not what Louisiana picked in this case. They're not what the court requires. The court gives the state, once the violation is established, the opportunity to draw its own map. So they're just showing, like that's just a step that you have to do as a part of your showing that we do have this vote dilution problem in this situation. And as Justice Kagan says, that's all based on current information.
Well, but the question is, what's that is based on current information? It's not a showing of intentional discrimination.
Why does it need to be? Is your suggestion that the only thing that's worthy of remedying is the intentional discrimination by the state?
If the remedy is stereotyping and race-based,
set aside what the remedy is. I just need an answer to the initial question, right? If I'm looking only at Section 2 world, we have a mechanism for identifying race-based vote dilution and other kinds of problems. Is your view that you only are entitled to some remedy for that if you demonstrate that the state intentionally is causing this to happen to you?
Well, that's not current doctrine under Jingles, but the problem is
that your argument? Is that what you're saying we have to do?
Our argument is that if you're going to allow a race-based remedy, it must be in response to intentional discrimination.
So you don't get a remedy for an actual dilution or problem with your vote, the kinds of things that Congress cared about and that the Constitution requires. You don't get a remedy unless this was intentional on the part of the state with respect to you.
Which is a constitutional vote dilution claim which people always can be bringing.
Thank you, counsel. Justice Thomas? Justice Alito?